So the Trump government wants to cut billions from Harvard University under this theory that it's some kind of a free giveaway to them. They don't need the money. There was a hearing on it. The judge is kind of skeptical for good reason, but I want to break it down because this case is a great example of illuminating the problems with the Trump government's approach to all these cases. And there are themes that just keep resurfacing over and over again, which tells us a lot about where the weaknesses are in the Trump approach to things. Before we get to it, explaining how that case, or this case, is a roadmap for all the weaknesses of the Trump regime, I want to remind you to subscribe because we illuminate these sorts of issues without just giving it this sort of breathless mainstream coverage, mainstream media coverage of like a spectator sport. Who's going to win? What do you think of these things? We want to put it together for you to show you what these things really mean in the big scheme of the Trump regime. All right, so here's what Trump had to say right after the hearing, meaning obviously there's no decision yet, but he's already opining on it. We'll put up the screenshot for you. He doesn't even need to hear the judge's ruling, right? He already knows what it's going to be. He says that she is completely out of control, quote, total disaster, which I say even before hearing her ruling. Trump writes, she has systematically taken over the various Harvard cases. It's an automatic loss for the people of our country. Says he's going to appeal the decision if the judge rules against them. He calls Harvard anti-Semitic, anti-Christian, anti-American. And of course, let's first of all point out, he says there's a trial. He's totally wrong about that. It's way too early for the trial. Actually, let's even put aside the fact of why is the President of the United States ranting and raving like this, right? Talk about cognitive concerns. But let's focus on the analysis here. And so, of course, he's wrong. It's not a trial yet. We're years from a trial. We haven't started discovery at this point. We're in this pre-trial posture called summary judgment. Very unique situation. The name suggests that it's early. It's a summary of the case to see if you can have judgment at this point. So here's the critical point. The standard for summary judgment requires that there are no material facts in dispute, and one side therefore wins just on the law. It can be a tough standard, right? Because many cases are about disputed facts. Here's the distinction. Harvard wants to say there are no facts in dispute. The government is discriminating against us based on our First Amendment viewpoint, and they have failed to follow the law. They failed to follow the processes in place for trying to show discrimination on the part of Harvard. That's what the Trump administration is saying. You're anti-Semitic, you're not protecting students, etc. And they've moved to withholding billions in grant money with no nexus to the alleged wrongdoing by Harvard. So at first blush, maybe neither side can win, right? Because there are lots of issues in dispute. But again, the point is, it's not the dispute that the Trump government wants you to think it is, meaning, did they do these things? Are the Jewish students being at risk? No. What is really in dispute here before the judge is, what are the facts about what the Trump government has done? And that's not in dispute. They basically said, we decided you're discriminating. We've decided you're violating Title VI of the Civil Rights Law, so we're cutting the funding. Here's the problem for Trump and his government. There's a whole bunch of things you need to do under the law in order to commence saying that there's been a Title VI discrimination complaint. You have to put forth the evidence, you have to have findings, you have to follow all the processes to prove that rather than just jumping to the end right away. And as the Harvard briefing put, there's a quote from Lewis Carroll's writing, which I really like, and says basically, they jump to the sentence, we're about the verdict later. That's what the Trump administration always does, right? And really, it's a pretense for violating the First Amendment. They just want Harvard, like they wanted the law firms to capitulate, like they want public broadcasting to capitulate, to only broadcast, to only give the opinions that the MAGAs want them to give. I mean, that's the very antithesis of freedom of speech, right? The president wants to tell you what you can think and express. I did an interview on CNN about this. You can find it here if you want to listen to the whole thing. And this was before the hearing. I made the point that Harvard may just win on summary judgment because the Trump administration's reasoning is so poor and so unbacked up. And even though it's very early in the case, it is undisputed what they did without going through the Title VI procedures. It's also undisputed why they're really doing this. And at the hearing, I'm sort of accurately predicting this, the judge was pretty skeptical about it. We can put up one quote from her here for you. And the judge says, what I'm wrestling with is this idea that the executive branch can decide what is discriminatory or racist. These ad hoc decisions without any procedure around it. And she put that question to the solo DOJ lawyer who showed up. Now, let's talk about that for a second because it illuminates a different point about the Trump government. This is becoming the SOP for the Trump DOJ. Sometimes high officials showing up arguing cases by themselves instead of all the normal people who are experts in the area arguing it. A case like this is an enormous issue, right? Billions of dollars at stake, taking on Harvard University. Normally a case like this will be heavily staffed. Having only one attorney shows up is certainly peculiar, but it raises the question of, one, how prepared can this one attorney be? And also, what preparation are they even bothering to do besides just putting out someone who can make speeches? The lawyer that showed up, that lawyer had worked for Josh Hawley, and in the Trump 1 administration had worked in the White House. So he's not a career DOJ lawyer. I'm not going to get into who it was. It's easy to look up because it's not really about like attacking that particular lawyer or like outing him or something. It's a matter of public record who it is. The point is, it's not a career DOJ lawyer. Maybe there are fewer career DOJ lawyers around. Normally, defending decisions made in federal programs, meaning this is a federal grant type program, that goes to, we've talked about this before, the federal programs branch. That unit has been decimated. 69 of the 110 lawyers have left or have announced plans to leave. That is a big problem, and it indicates what is working and what is not working at the DOJ. We'll put up the article for you about that. The 7 lawyers who are willing to speak with Reuters talked about having a punishing workload, the need to defend policies that some felt were not defendable, basically, among the reasons for leaving, and they're being pressured to leave. So the Trump administration, the Trump government, doesn't get the fact that by having this short-term win, meaning we're getting rid of these people, right, the deep state, they don't understand that they are losing the experience of the department. And they think, who needs that experience, right? But they're not doing well in these legal cases, and they're not going to do well in the future because they don't have the people who actually know how to defend these programs. That says a lot about their approach. So the summary judgment, whichever way it goes, is going to be appealed. Hopefully, in the meantime, if Harvard wins at this stage, litigation may continue, right? Because it's just summary judgment is going on here. If they lose, rather, it will continue. But hopefully, it will continue while the grants are going forward. Because the grants are for really important things. Cancer research, Alzheimer's research. There's a clinical trial 7 years long for preventing infant deaths from allergy reactions. Those families are out of luck right now. That 7-year trial stopped. No money for it. Their children's health is endangered, and maybe things that could help so many other children, all being set aside for what? Well, here's what is being set aside for. Take a listen.
Harvard only has 3%, by its own numbers, 3% conservative faculty. Do you think they are allowing enough of viewpoint diversity through that teaching
Where
on
in
campus?
where in the statute does it give you the ability to cut off federal funding for a university based upon your decision, your determination that they don't have viewpoint diversity? Can you cite to a statute, an authority that Congress has given you to micromanage the viewpoint diversity of a college?
Well, certainly well, now let's back up.
Well, no. I think that's really important. I'm
going to answer your question.
Can you cite a statute? Because you can't cut off funding for universities unless you have a statutory authorization to do so. So what statute gives you the right to tell any university that they have to have a certain mixture of viewpoints?
So here's what happened with Harvard.
No, it's a pretty simple. I don't mean to provide a being hostile.
Well, I have to give you some. I
think you have to
some
cite the
background.
statute.
The statute's Title VI. These were civil rights violations. That is why we filed a case and defunded or stopped the funding for a while for Harvard, as well as we did Columbia. And in that conversation with them, we talked about different things that they should do coming back to the table to make their programming better. The president of Columbia absolutely indicated, as well as the president of Harvard, that they needed to do things on their campus to eliminate anti-Semitism. That was kind of the crux of what brought us into talking to the different universities. And then we sat down with them to say, okay, these are other issues that you need to address on your campus because you do receive federal funding.
I am
and
well
under
over-
federal funding, if you are breaking the
I
law,
am
which
well
they
over my
did
time,
under
but
Title VI.
I don't
Well, that's-
understand
I've
any
answered your
conception
question.
of
It was
civil
Title
rights
VI.
law to give you the authorization to micromanage viewpoint diversity on campus. That's not authorized under the civil rights title provided to you by the United States Congress. Thank you very much.
So the secretary there, she's quite clear that they're seeking to police viewpoint diversity, right? It's only when she realizes that she's getting her head handed to her there after saying that she tries to get back to, oh yeah, I forgot. We're really talking about discrimination here. Harvard's being anti-Semitic. It all goes back to trying to connect it to the civil rights violation, but it's not. It's really about just viewpoint discrimination, trying to punish Harvard for its supposedly overly liberal viewpoint. And she says that quiet part right out loud immediately because that's what it's really about. So again, the summary judgment standard, it doesn't matter whether Harvard actually does or doesn't have a liberal viewpoint if they don't have enough conservative voices there. That's not what's in dispute. What's in dispute is that the Trump administration wants to punish a point of view. They want to win on that. And therefore, as a matter of law, the First Amendment may be violated. Always, the Trump government puts control, not even really ideology. The ideology is one of control over safety, over good governance, over anything else. And that's the message we need to keep shining light on, driving home in the midterms. Because in each and every federal, local, state election, every federal, state, local official needs to be reminded that this is a distortion of good governance. It's a distortion of democracy and is an incompetent effort to distort it. That's what we have to keep in front of everyone. There you have the Secretary of Education blundering into an admission that they're just trying to regulate viewpoints, a textbook example of a First Amendment violation. That's the kind of incompetence that reveals the kind of distortion of the democratic values that the Trump government's really up to. That's what we have to keep shining the light on, and we will. We'll talk to you soon.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.